The goal for this class is for you to understand that equity is going to lead you to be able to shut down misdemeanor cases, traffic cases, civil cases, eviction, divorce, custody, estate issues, and more. You're going to learn that you have equity in all situations and how to protect it, how to handle the situation. To be able to understand the difference between a U.S. citizen and private American. To understand that this is not sovereign citizen activity. What qualifies me? What qualifies Amir? I have 7 years of studying exclusive equity. So 7 years of experience, not in just one state, not in just one court, across the nation. I've been the go-to guy way before I ever started building a platform on Instagram. I've helped close and settle almost, well, at this point, over 1,000 court cases. I've beat 4 of my own personal cases, including 1 warrant. I've settled, at this point, over $4 million in debt in taxes since 2019. I've beat state and federal felony and misdemeanor court cases. And unlike majority of people out there, I have the proof and testimonials that I drop weekly. So how did I get started? Really, I started learning, well, let me take y'all back. A guy I went to school with started calling me God, started calling me king, like that. So it sparked my interest, sparked my mind. From that, I started learning more about the true knowledge of the land of America and, Black Americans. Started learning more about God's law, which is equity, natural law, trust, suretyship, versus man's law, which is codes, statutes, policies, rules. Then guess what? Like most people, I got jammed up. I was charged with a traffic warrant. So in that moment, what was it that I needed to understand? The same thing that you probably need to understand. U.S. citizens are viewed as government state property, public citizens, incompetent, wards, minors, etc. Private Americans are viewed as sovereigns, private civilians, creators, grantors of the government, competent, able to handle own affairs. I also needed to have the mindset that trust law is the highest law governing the land of America, and exclusive equity governs trust law. So the biggest problem that occurred that I had at the moment, probably again, the same thing that you're running into, is knowing how to execute. Had no mentor, no program, and just overall feeling like I'm not being prepared. I'm not the best prepared. So what I did was I created a plan to study Suits in Chancery by Henry Gibson for 6 hours a day, 5 days a week minimum. Now, if y'all been following me, y'all already know Suits in Chancery is the #1 book that I say you guys should read. And if you're new to me, if you're new to my platform, then go out and get that book. You can find it online. You can find it online for free or order it. It's absolutely the #1 book to lace your boots. So the end result I achieved was I shut down the traffic warrant 2 weeks later. Just 2 weeks later, it disappeared. Also, during a trust, a retired federal judge told me that my trust was one of the best in the country. This is a retired federal judge. It don't get any better. So in that moment, I felt the power of God in exclusive equity without being a lawyer. All the testimonies that you see on my platform They felt the same power. That's true power. It's the same power that you want. So after 7 years, y'all, I discovered the hard way. And you know, if you've been struggling, I'm sure this is why. There's no one remedy to beat every case, but there's a huge difference between a private American and U.S. citizen, AKA the consumer. Let me fill y'all in on a little bit. So lawyers, U.S. citizens, consumers, they use U.S. codes and rules as an authority for power in law. U.S. citizens and consumers use state driver's license, social security cards to identify themselves, all made from the U.S. government, the Washington, D.C., and the corporate states. This authority comes from man's military law, which is the direct opposite of God's law, which is the Christian Bible turned into exclusive equity. It's 600 years of jurisprudence of case law. So, no, you can't call this sovereign citizen activity. Sovereign citizens are against the system, and they're going to look at millions of different case law all over the place. That's not how we get down. And when you pick up Suits and Chancery, you'll begin to read and understand this. You'll be able to understand why I get the remedies that I get. We use equity maxims and Bible scriptures as children of God and ambassadors bearing the kingship of heaven. Lawyers have an allegiance to the court system, the judge, that is superior to the attorney-client relationship. So if you don't understand what I just said, if you get a lawyer, whatever you tell him, he has to tell the court. Who's the court? The prosecutor, the judge, the court officers. So that's why whenever you see on TV and they're brokering deals for their clients, that's what's going on. Because they have an allegiance to the court that's superior to your attorney-client relationship. This is in corpus juris secundum, their law, basically. A U.S. citizen is a public government federal employee. You cannot be a child of God exercising man's law. It's just the way it is. You cannot serve two masters at once. One's going to be jealous. So allow me to show you a visual of the difference between a U.S. citizen consumer and a private American. It's the ledger for the United States government. This is the public ledger. Only the public ledger is what you're looking at. This is pretty much the only ledger that majority of people know until now. Right side, you got the liabilities. This is the debt. This is district citizen, which is a U.S. citizen, a consumer. What most people think they are on here. Obligors. You're probably more familiar with that term, dealing with child support. Some of y'all on here. This is where commerce lies. Artificial person. Artificial person, that's the birth certificate name. That's businesses. Absentee is a person who abandoned their state. I could go on here. Heathens, idiots, lunatics, wards, statutes and codes. Now on the left side here, we got the assets, the credits, right? So when consumers say, I'm the original creditor, well, this is where they at. You got the secure party creditors, when they express themselves, well, this is where they're at, on the asset side, which is, you would think, a good thing, right? And I'm not saying it's entirely bad, because I love the work that consumers do. However, we just getting down to the root of it. They lie on the left side on the assets, but this is just the public ledger. Now, on this asset side, you still don't own anything. You are what we call conquered booty. You're still operating under the Emergency Banking Act, the War Powers Act. You're still within the territory under Congress, Article 1 jurisdiction. You're still under man's military law. So it's not really where you want to be. If you ever own something, but you're still paying taxes on it or anything, you're just paying something on it. That's because you're still right here on the asset side of the public ledger. You don't truly own it. You don't have equitable title, but we'll get into that later. So, and this is the private ledger. On the right side, we've got the liabilities again. If you have a private trust and you're a trustee of that private trust, this is where you're at. Now, the public ledger that I just showed y'all, that's like fake. It's a shell of the substance of the, let's just say, the real deal. It's a shell of the private. So now, if you're a trustee of a private trust, you actually hold real legal title. Whereas if you're a trustee of a domestic trust in the public, that's a fake legal title, a shadow legal title. We go over more of that in the academy. Now, finally, on the left side here, we got the assets, the equitable assets, where you hold absolute title. This is where private Americans, private citizens, private civilians, cess decay, the beneficiary, equity, substantive rights, heirs, executors. This is where they belong. I mean, no executor, I'm sorry, but heirs. You get your cases sealed, where you, if y'all ever heard me say you can write your petition with a crayon on toilet paper if you're locked up, this is where you can do that at if you're a private American. You can't do that on the public side because they want to see the form. They don't care about the substance. They don't care about what you're saying, your intention. So now here's the big picture, the overall picture. Now you can see far to the right is where the U.S. citizen is, and far to the left is a private American. On the right side, fake law. On the left side, the real law, organic law. You can see that's worlds apart. A U.S. citizen is nowhere near a private American. They're on opposite sides of the ledger. When we tender a special deposit to somebody in court or to these CEOs or companies or whoever, right? That value is coming from the left side, from the private. That's where the value is coming from. Let's go. So, another thing, property holds the same status as the master title holder. So let me break that down for you if you ain't already connected the dots. Now, if you're a U.S. citizen, which I just told y'all is essentially government property, right? So if you're a U.S. citizen and everything that you obtain, you use the Social Security number and your state driver's license, you use all these credentials to obtain it, right? Now you think it's your property, but you are looked at as government property. So is the property that you think you own. If I go out and I buy a dog and my dog goes out and he comes back with a bone, well, guess what? That bone is mine now too. It's the same thing. That's why you need to correct your status and be a private American. And that's why I do it through the courts. I don't just make a declaration and go record it. I'm not saying that's bad, but I like the way I do it. I like the way I do it because if the feds come knocking on my door, they'll be looking for that all-cap name that's on that birth certificate. Meanwhile, I got a record from the courts, from 3 judges or three court officers that says, hey, he's not that name on the birth certificate. He's this name on this court document. You can't confuse the two. My paperwork literally says that, amongst other stuff. A gang of other stuff. But it literally says that. And I'm not telling y'all stories that haven't happened. Not to me personally, but again, my peers. That's a story that has happened to my peers and to other people that I've helped. Come knocking on the door. They're looking for that name on the birth certificate. Always, or 99% of the time. Go ahead and pull out your record and say, mistaken identity. Sorry, can't help you. Here is a testimony from a young lady who did this in Indiana. Got her status corrected through the courts. I'm not going to read all this. Y'all can speed through it if you want or whatever. But essentially, she did her petition. She filed everything how she was supposed to. She ended up having a court date. Now, at the hearing, judge asked why she wanted to do this. She said, I want to prove that I own my name because the name on the birth certificate is not it's not me. And it's hearsay. It has no wet signature. The styles of the name on the BCR, on the birth certificate are incorrect, which means the mode of the name is foreign. It's not equity, it's military. The state of Indiana is at the top, which means the state of Indiana created that name and owns that name. You know, when you get a piece of paper and you're writing a letter to somebody, you put your name at the top. Or like at school back in the day, you put your name at the top, right? To signify that you own that paper, right? So the teacher will give it back to you. Same thing here. You have a record that the state created. Where's your record? I also have a statement of the intent from the testatrix that she intended to give me the name being brought forth today. That's basically saying my mama intended to name me this and style it this way, and the mode behind that name is sacred. That's not the same thing as this foreign name on the birth certificate. Judge smiled and said, congratulations, good luck, and that was that. And we have many other testimonies like that. So this is not a game, this is real in the field, no sovereign citizen activity. Let's go. So when there's a conflict between the rules of equity and the rules of law over the same subject matter, the rules of equity shall prevail. This is Professor Pomeroy. There's another golden master of equity. All of his books you should order. All of them. I have half of them and probably the other half in a cart right now. I have all of it on PDF. I'm going to say this again. When there's a conflict between the rules of equity and the rules of law over the same subject matter, the rules of equity shall prevail. Do you understand what I'm saying to y'all? This means when God gets involved, God always prevails. That's what I'm saying to y'all. This is why when people come to me talking about consumer law and all this, I'm happy for them. However, it doesn't move me. It doesn't make me want to get into consumer law. I walk a narrow path following God's law. So let's get into it. Of probably the number one reason why y'all have been failing your court cases, right? Equitable actions. The order in which defenses must be made. Now, let's show a raise of hands or drop a comment in the chat. Tell me how many of y'all move straight into motion to dismiss or motion to this, motion that, motion this. How many of y'all recognize that a lawyer is immediately going to motion to do this, motion to do that, motion, 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 right? Now, if you're looking at my screen right now, you see motion is number 2. What about number 1? Why don't your lawyer do number 1? Why don't he never do an abatement? Why he not challenging jurisdiction? Why he not doing none of that? Ask him that. Please, in abatement, this is where you challenge jurisdiction. That's what an abatement is. We're going to go over that a little bit later here. But essentially, that's what an abatement is. Quo warranto, it's the greatest abatement. It's the greatest way to challenge jurisdiction. Bill of exceptions. Removals. All of this happens before motions. You want to move it to a higher court? Do that before a motion. When you motion, you waiving all of these defenses. Most of y'all are going straight to number 2 or number 5. And if you've been following me, then you know, like, challenging jurisdiction is cool, but I'm all about settling the matter. And when I challenge jurisdiction, I'm not doing it the way other people are. We'll get into that, though. So, plea of abatement. Plea of abatement in equity is a defense raised, which is a branch of law that focuses on fairness and justice. That's God's law, equity. It's typically raised in response to a claim filed in an at-law public court. That's your everyday court that you walk into, man's military court. Now, if you haven't figured it out yet, equity is the private side of the court. Yes, the same judge will look you dead in your face, cussing you out. Once you flip the script to equity, that same judge will look you dead in your face and be your friend. Will call you by your first name and act like y'all long friends of 20 years and he's there to help you. Yes, it's weird as hell, but that's the way it works. You flipping the switch. You're changing the mode of the court. So, a plea of abatement may challenge the jurisdiction of the court, standing of the plaintiff or other procedural defects in the lawsuit. Again, the mode of the court, the what else? The styling of your name, the mode behind your name. Is there an Article 3 judge? Which Article 3 judge is operating under equity? If he's Article 1 judge, then that's executive. That's your everyday regular court, regular judge that's yelling at you. That's not what you want. So the two never can be confused as the same, and neither can use the law of the other. Both are bound by the respective laws of the Creator. Being under different laws, there's a conflict of laws. For example, each mutually excludes the other's authority of law. So when you're in a public court and you haven't flipped the switch yet, guess what? You might be expressing yourself and he's cussing you out or railroading you. That's because he does not respect God. He doesn't respect God's law. He doesn't respect equity. If you get into a court of equity, right, in the sealed, you're in chambers or whatever, guess what? If you start talking about codes and statutes and stuff, you're going to see that judge go from being your friend to your enemy. He's going to start cussing you out or all type of stuff. You can literally see the analogy of law just by paying attention. So this is considered by both opposing laws as the ultimate conflict of law, which is the basis or substance of their creation. God's law and man's law are opposed at every point in creation. In support of this conflict of laws is, God is no respecter of persons, but man's law is. See Acts 10:34. So yeah, essentially, God is not a respecter of persons. So essentially, what has happened, government powers have created the persona to give an appearance of lawful process, but such is a persona created by novation. The purported law of the persona is not law because it is directly and blatantly contrary to God's law and common Christian law. It's based, founded, and rooted not by God, but by the law of war through its lineage to the god of war, Mars, and the god of commerce, Mercury. Military law. So, the doctrine of waiver arises. So, going back to the motion, when you enter that motion and you didn't do an abatement, right? You skipped that. You skipped that. You went straight to number 2. You skipped that. The doctrine of waiver arises and you have forfeited or to be considered as having already expressed the prior defenses. That means you waived challenging the jurisdiction. You was cool with it. You said, okay, I'm good with this. Let's go. This means you move further into this jurisdiction. This is also how a lawyer defaults you to status of a state ward. Now, the original plaintiff's process must have no errors in it. Errors constitute defective process and are sufficient cause for a defendant to issue an abatement. A misnomer is a fatal error in any suit in equity or at common law. Basically, that name is not styled and spelled correctly, that's an issue. If you wasn't served correctly, that's an issue. If anything is not how it's supposed to be, basically, it's an issue. Now, when it comes to appearance, including the statutory special appearance, places the party before the court in order to participate in the action. All right? An abatement is not an appearance. Now, the way I do things is I don't typically like to do an appearance, but I know it's different depending on where you're at and where where you're doing business at. So like I know on the East Coast, they really strict with that. So you got to come with a special visitation. People visit places. They don't just appear like ghosts. Enforcement. A plea and abatement must be sent to the judge's chambers to have effect. The best practice is 2 weeks before the hearing. This is giving notice to the judge, right? Because anytime somebody come over your house and they didn't call you or let you know, you get mad. You get mad at them. Why? Because they ain't give you notice and let you know they was coming over, to give you the opportunity to say whatever, do whatever, basically be prepared. You want to extend the same respect here. We doing big business. Whether you believe it or not, this is extremely big business that you're doing. The biggest. Nothing is bigger. I would say maybe 4x, but it's not even bigger than this, honestly. So now, when you do your abatement, the case could potentially disappear or nolle prosequi, however you say that. It's basically dismissed before you file as a before you file as a plaintiff. So a lot of times people want to see actual court paperwork and stuff like that, and all we have is testimony, or we might have other paperwork, but it doesn't show what people really want to see because they don't understand exclusive equity. All they know is the public law side where it says case was dismissed for this reason. But what we are doing a lot of time exposes them. They don't want a windfall. Again, we are dealing with potentially tens of millions, hundreds of millions, billions, higher than that. This is the type of money that we're dealing with that's bankrolling these court cases, all right? So now, you can also file a bill of exceptions. What is this? This is your objections to the court case. So if it goes past your abatement, right? If it doesn't disappear, then you can file a bill of exceptions. This is again you objecting to everything that's going on in the court case. You can keep amending it because you're doing equity. You're expressing equity. So you want to say, hey, objection. Equity would have ruled this way, or equity would have looked at it this way. All right. Now, you also want to obtain a certified copy of the court case transcript. Then you'll need to file a trial de novo in equity as a plaintiff, or it could be called something else, writ of error, bill of review, something like that. So the biggest key for y'all, write this down right now. Pay attention. A lot of people struggle with this. 99 people struggle with this. All right? Now, listen closely. An abatement may not be recognized until appeals. All right? So a lot of times we send in court warrantos, abatements, challenging jurisdiction in different type of ways, all this, right? Now, when it doesn't get respected, you get railroaded. You're like, dang, they acting in dishonor. They playing with me. They don't know the law. Blah, 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 all this, all that. No. You just coming in different. And they don't really have the authority to shut down the case the way you want to. Or you may be getting tested. Whatever the case may be, there's plenty of case law that lets you know your abatement may not be recognized until appeals, where you are the plaintiff, because the plaintiff sets jurisdiction. So basically, just to keep it all the way real, when you challenge jurisdiction, y'all half-assing it. And that's why you're not getting the relief that you're looking for. Trial de novo. It's a new trial on the entire case, where both questions of fact and issues of law are determined as if there had been no trial in the first instance. Trial de novo preserves your interest in the law of the land. Think in terms of constitutional remedy, civilian due process, jury mode, right to face your accuser. A trial de novo in equity is a legal proceeding in which a case that has been heard in the lower court is retried from the beginning in a higher court. Ain't that what y'all want? Y'all in the lower court expressing an equity right, railroad you. Now you doing a trial de novo and appeal saying, hey, equity would have ruled differently. Now we're in the higher court, higher vibrations. Equity is a higher vibration. Lower court, statutes and codes, military, y'all get the point. A trial de novo in equity is often used in cases where the lower court's decision was based on discretionary or unequitable considerations. Equity provides a mechanism for parties to seek a fresh hearing of their case in the hope of obtaining a more favorable outcome. Discretion. Everything is military discretion in the public. You want the judge to basically have a God-like conscience. God is all about love and redemption, correcting your mistakes. This is what you want. Military is war. It's all about killing people, taking no matter what. If I see something, I want it, it's mine. It's destruction. All right? So now, civilian due process. When I plead de jure, I enumerate a minimum of the principles included: civilian due process, lawful money, separation of the power, union, etc. And I'm also going for remedy under grace. I'm not arguing. I'm praying for relief under grace. God gives grace. People have problems with those words, and that's your ego. So now, Sixth Amendment protects criminal defendants in criminal proceedings. The amendment guarantees criminal defendants the right to a speedy trial, the right to trial by jury, the right to know the charges and the identity of their accusers, the right to confront their accusers, the right to legal representation, and the right to not be compelled to testify against themselves. These rights are essential to ensure that criminal defendants have a fair trial and are not subjected to unfair or arbitrary punishment. You need to demand civilian due process, demand a right to face your accuser, demand your right to see a judge before being incarcerated, before being detained. Demand a jury of your peers of private Americans, not U.S. citizens. You know why? Because U.S. citizens don't think like you. I'll give you a perfect example real quick. Now, if you run a red light, a U.S. citizen is going to say, yes, you ran a red light, you committed that crime, you need to pay the fee. Now, all right? A private American is going to say, yes, you ran a red light. You committed a violation. However, you did not commit a crime. A crime is when you injure a party, you injure someone, you hurt someone, or you damage their property. Running a red light might be a violation, but it's no crime. And like my guy said, the difference makes the difference. You got to make the distinction. Now let's get into a quo warranto. It's the greatest abatement. Again, it's the implied sovereign of we the people, asking by what de jure authority do you have to act, to do what you're doing against me, to me, whatever it is. Private Americans are within the meaning of the state, the original Constitution. The District of Columbia is not within the meaning of this proper lowercase state, but is within the meaning of the all cap state, codified. It's a district. It's not basically it's not the same standing. No. All municipalities, businesses, cities, states, they all derive their authority from Washington, D.C., which I just told y'all isn't a real state. The real state is the people. The people on the land. That's the real state. DC is just 10 square miles or whatever. You have to understand that jurisdiction. You can literally use that if you understand how to use it properly against majority of businesses out here who are not operating against you correctly. There's 3 different modes. You can send it to the judge's chambers and all parties can file it on the record, or you can send it to the chief judge, use process server on the senator or attorney general. These are the 3 different modes that I like to talk about. Mostly talk about the one to the judge's chambers. Now, again, so let me get further into this. A quo warranto, if you're looking to liquidate someone's company, this is how you do it. When I go hard about quo warrantos, I'm looking to liquidate your entire business, your entire entity. And I know how to go about it properly. You'll basically have to prove that you have a de jure authority to which you cannot do, to which majority of these people don't even understand. I won't have to prove it. They'll have to prove it. That's case law. Now, what are people saying in Matisse Academy? This is what people are saying. They feel like this information is going to save their life. It's a great program. If you work it, it works for you. Take a minute to look at all of these testimonies. I know I got plenty more, but this is what they're saying. These are people in the academy. More testimonies. 5 cases dismissed. I really don't even remember this person, to keep it all the way real. I just be talking to people and be giving game, just whenever it's on my heart, just to give it out. Boom, 5 cases beat. Pointed somebody in the right direction, took my advice, applied to equity. Boom, a year later, still ain't heard nothing. No case found. Just told y'all cases be disappearing. My guy now a CPA, but he would turn the IRS into your best friend. Pause for a second. IRS, a lot of people scared of IRS, but the IRS is your friend. They act in equity. If you know equity, they're your friends. You can get to the bottom. Basically, it's a whole lot easier to settle and close a problem that you have with the IRS if you're doing equity versus anything else. I promise you. A lot of people been hitting me about custody cases. The time is now. Nobody can beat me in a custody case. Nobody. And I stand on that. Civil debt, small claims testimony. Y'all can read through that real quick. I'm going to skip to the end, though. He basically was expressing equity, was expressing suretyship. Had a little couple of bumps in the road or whatever, but ultimately, he said, dude smirks at me, the bailiff, the recorder, the other court staff in the room had no, let me back up. He said, ask him to call me, let's just say Timothy, as that's my name granted by my mother, and he resisted until I remembered. I grant my name by special deposit to the court for a future return of my interest. Now, y'all probably puzzled about what that means. That's essentially trust law. The judge is typically stealing your name, using it to bankroll the court case. Your name is the estate. The estate is the value. When you grant your name to the court, you're saying, hey, I'm going to let you use my name. You're a fiduciary trustee. The money y'all make, I need my cut. That's what you're saying. You talking trust law. All right? Said the dude smirks at me, the bailiff, the recorder of the other court staff in the room had no reaction that I could discern. He spins in his chair a full 360 degrees, asks if I have anything else to say. I pray that equity be done. He dismisses with prejudice. Now, if y'all seen my skit where I've done that before, I did that for a reason. I think this is the 4th time this has happened. This is the 4th time in 7 years I've heard a story like this. 2 of them has been mine. It's the analogy of the law. You flip the mode. You switch in the mode from military to equity. That's what he's doing when he do a 360. Just more testimonies. 13 tickets, warrants dismissed. My good friend Tia, helped her out. I got testimonies for days. Your favorite guru don't have testimonies for days. He can't or she can't even drop them every week. So you'll be able to get rid of child support, child custody issues, debt obligations, traffic tickets, misdemeanors, divorce issues, CPS issues, school issues, title issues. Listen, y'all, anxiety in court, anxiety with police, the fear of law. You will become a master student. I am trying to build master students. All right? That's what I'm about. I'm not trying to be around people that's essentially just trying to do a process and get in, get out, and just stuff like that. I want people that really want to learn, want to become master students, want to be able to shut down court cases, that want to feel that power of exclusive equity, that God power, have that confidence. That's what I'm looking for. That's what I want to help you with, to become a master student, for equity to be engraved in your soul. Because equity, I'm just going to keep it real with y'all, it got to be in you. Can't be on you, it got to be in you. So this is what Matisse Academy is all about. It's a total, well, basically, we're going to go down the list. So it's step by step how to be a private American. Y'all can see the values on these. And really, these are undervalued. But so this is an entire discussion. Get step-by-step instructions on pure equity, trust, and accounting. Like I always say, if somebody like me come and audit your trust, for one, what kind of estate are you holding? A legal estate or equitable estate? That probably just threw you off, right? You ain't even know about that. We learned about that in the academy. Your ledger got to be on point, because if it ain't, I'm going to audit you. You might as well have nothing. The assets might as well not have been in trust. Going to learn about suretyship and special deposits in depth. Going to learn about CPNs, credit privacy numbers, the proper way. Learn to secure auto cars and the titles. I got like 3-4 different ways. I've been securing cars and titles for over 10 years. I got a best friend who has car lots, who brought me in the game, taught me different things. So I'm giving you the public way, and I'm giving you a private way. Some cars I want the state title, so I can put on Turo or rent them out, flip them, whatever the case may be. Some cars I want to keep for myself, throw them in trust. I don't care about a state title, but I care about the bill of sale. Care about conveying it to a private trust, having that proof. I'm giving you all those ways. I'm giving you the way how I set up my program to find these cars. Learn to beat traffic tickets. Y'all know I started off with traffic tickets, traffic warrants. I'm the best in the game when it comes to that. Traffic tickets is 100% suretyship at 7 years. I have the most experience dealing with traffic tickets. The last 3 years, I've been going hard with civil and criminal. All right, gonna learn more about the equitable actions in court. Learn about mortgage foreclosure defense and extinguishment. Guess what? We just shut a couple foreclosures down with abatements. We just shut child support down with abatements.